Hello everyone and welcome to today's Mondac webinar in association with the law firm Katten, who will be providing comprehensive analysis and guidance on key changes in the UK HR landscape. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Christopher Hitchens is an employment lawyer who advises on all aspects of company operations. He is also the office managing partner of Katten's London office. As such, Chris not only advises clients on the full range of HR and cultural issues, he also has to put into practice in his own workplace. Chris's advice focuses not just on the legal issues, but also on the protection of a client's culture, as well as its reputation as an employer. Chris and his team add value for clients by finding ways to conform with the law that enhance their retention and recruitment efforts, while also reducing legal risk. Bridget Weaver is a senior associate in the employment team at Katten, who focuses on a broad range of contentious and non-contentious employment issues. Bridget's contentious experience covers both employment tribunal claims and high court litigation, with a particular focus on restricted covenant disputes. Litigious work also includes issues of unfair dismissal, discrimination claims, and breach of contract. Her non-contentious experience comprises employee relations, advisory matters covering the full range of employment law issues such as holiday pay, performance management, and advising on family-friendly rights. Now, before I hand over to the panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. And between each section that we have today, we will have some time for those questions. So please do send those in as and when you want a question answered. We'll endeavour to answer as many as possible. It's now my pleasure to hand you over to Chris and Bridget to begin. Thank you.
Thank you, Dan. Afternoon or good morning, depending on where you're joining us from. So as Dan explained, as well as being an employment lawyer, I'm also the managing partner of Katten in London. So as a result, I get to stress test my own advice, see policies in action. And that means that workplace culture is incredibly important to us here, but it's also very important to the way in which we advise our clients, because our aim is to understand your culture, because that will shape our advice in getting you to the end destination that you want to get to in a way that enhances your culture. So we do that by understanding trends in your workplace, trends in the marketplace that we see other clients getting into, and we do a bit of crystal ball gazing so that we can predict for you how things might end up. And because we advise a lot of clients who are international, in particular clients who have a US headquartered operation, we do see a recurring theme that what happens in the US may come across the pond and happen in the UK months, weeks, years later. So that is an important element also to the way in which we advise. So what we're hoping to cover in the next 45 minutes, 50 minutes or so is looking at these trends around certain topics. So getting people back into work, potential changes to rights at work, and we're thinking there about a general election coming up possibly in the next 15 months. The direction of travel relating to the freedom to move jobs, both in the UK and in the US, and particular types of in-work issues that we are seeing in the current landscape. And as I say, doing a bit of crystal ball gazing to enable you to address any questions that you might get from the C-suite to get ahead of those questions and to come up with solutions that what works best for you and your organization and your culture. So specifically introducing the topics that we're talking about, sickness absence is a hot topic, and we'll look at trends and developments associated with that and why it is such a big issue. As I mentioned, there's going to be another general election. The latest that the election has to be held is January 2025. They normally occur in May. I read somewhere that it was estimated to take place in the autumn next year, but still within 12 months. There are some legislative changes that have already been proposed. We're going to look at a few of those, but in particular, we want to focus on non-compete restrictions, because if they come in, and they come in both in the UK and in the US, I think that will quite dramatically change what we have drafted at the moment and how you go about protecting your business in the future. That's a fairly major change if it comes in. I feel that types of issues that HR practitioners deal with are cyclical. I will look at the cost of living crisis and how we may draw parallels from, say, maybe 15 years ago during the financial crisis, and what we saw then and how we might then be able to deal with and anticipate what might happen over the next 6 to 12 months. And then finally, we're going to look at an issue that's really arisen through hybrid working and modern modes of communication that have crept into the workplace. So WhatsApp, Slack, other instant messaging systems, and how they can really get you into trouble, but more importantly, how you might be able to spot that in advance. So the backdrop to long-term sickness is that 2.6 million people are currently economically inactive in the UK. Economically inactive means that they have been not able to work in the last 4 weeks, and they're not going to be looking for work in the next 2 weeks. So it's a number that applies to people who are not in employment. There are also obviously a lot of people who are in employment who are signed off on sick leave. So of the people who are economically inactive, 2/5 have reported 5 or more health conditions. So it's a multifactorial problem. But the most prevalent of those health conditions was depression or anxiety, but it wasn't the main factor. It was another factor in the reason why people couldn't work. So the cost of providing disability benefits has leapt to £40 billion. And as a result, it's a political issue. And Jeremy Hunt labelled his budget in March this year as the Back to Work budget in an attempt to address that economic inactivity. So depending on which side of the political spectrum you're looking at it, you could either say that there are some quite cynical measures here in order to try and generate more tax revenue from people who aren't currently working, or you could say, I suppose, that there are some measures here which are designed to facilitate people coming back into the workplace when a doctor has signed them off and not really given them anything else to work with. So in the first bucket, you have a tightening of eligibility criteria for certain benefits, the requirement to actually be looking for work to receive certain benefits. In the other bucket, there's some talk about expanding the role of occupational health, perhaps having that as something that an employer gets subsidized to contribute towards, and recommending changes to the doctor's fit note system. And I think we all get quite frustrated if somebody is off sick and you simply get a stress at work or anxiety or too ill with no color to it whatsoever. And sometimes it can be for several months and you don't know how to necessarily to move that forward for the employee's benefit as much as your own as the employer. So those are some of the changes that were proposed in March this year. But long-term sickness and health issues aren't obviously something new. But what is interesting, I think, looking back over the last few years, is the change in the rhetoric. So the Health and Safety Act and obligations regarding health and safety originally applied to manufacturing workplaces, to offices, and providing the right workplace equipment. We are seeing for several years now an increasing amount of recommendations around mental health, around workplace culture, around promoting psychological safety. And that, while there is no new tangible law that you can point to that gives an employee greater remedies than before, it is most definitely the direction of travel. So I've highlighted there the 2017 Thriving at Work review. This was an important piece of work that recommended core standards to be followed to ensure better mental health in the workplace. So things like having promoting a work-life balance, to having mental health first aiders, to having good communications around mental health, having monitoring systems, etc., etc. But these are only recommendations, they're not law. So there's no penalty or no obvious penalty for failing to follow these core standards. But we know that regulators, for example, the Financial Conduct Authority, or as a firm of solicitors, our own regulator, the DSARs, place workplace culture kind of at the center of their policies and principles. So in order to be fit and proper, or to be a senior manager within a regulated financial services entity, you need to enhance the workplace culture, both from your employees' perspective, but also from your clients' perspective. And therefore, we're seeing it in black and white in a regulated environment, if not in black and white on a statute book. So as I say, there's no major new legislation, and mental health claims, somebody has a claim for stress, anxiety, it's a psychiatric illness that comes under the personal injury legislation, although there is a way, and we'll look at this a bit later, there is a way in which it could come under the protection of the whistleblower legislation as drafted. So there's nothing new in the law, but there's a most definite shift over the last 5, 6, 7, 8 years towards workplace culture and an employer's responsibility in respect to that. I'm going to hand over to Bridget, because we were talking earlier and Bridget's got an interesting perspective on why this might be the case.
Thanks, Chris. Yeah, well, I think what we're seeing more and more of is this kind of idea that if you join a business and they represent themselves in their marketing and all their fluffy brochures, that they are a business that supports you, that's work-life balance, that they're here to encourage you and promote you, they're a good employer. That if you then suffer stress, anxiety, you don't feel supported during your employment, there's a sense of misrepresentation or injustice, and we're seeing that in quite a lot of the claims that we're dealing with at the moment. It's not necessarily a legal right, but it's certainly something where people feel principled, and I would say it tends to be more in those sort of new entrants to the job market, the Gen Zs, who feel, in my opinion, in my experience, that they're more likely to hold corporates to account as consumers, and therefore they're more likely to hold their employers to account. So I think that's quite an interesting change in what we've seen over the last few years. Yeah.
So I think that's the landscape that we're dealing with. One change that has come in that kind of pertains to this, as I say, there's no new major changes in law. There are ongoing changes. Yesterday, for example, the age for auto-enrollments came down from 22 to 18. There was a change earlier in the week to try to give people who work in the gig economy, so on a 0 hours contract or an agency worker, the ability to request certainty of terms. So these sorts of changes are happening. I don't label those as major changes. I don't think that's necessarily within the bucket that we're talking. Something that's on the statute book for 2024, which is interesting because I think it signposts again the direction of travel, but it's something that you'll have to deal with, is this right to request flexible working from day one. So when it first was mooted, I gave it relatively short shrift because it was mooted during or in between lockdowns or coming out of the second lockdown, and we were already working in a hybrid manner without really changing terms and conditions. So my contract will say my place of work is St Paul's, London EC4, and yet I work 1 or 2 days a week at home, and yet nobody has documented that. It's just become the way that I work. Has it become a custom and practice? I don't think that it has. I think we've still got that flexibility. But here we have a law that will say you have the right on day one, i.e. before you start work, essentially, to say, I would like to work flexibly. At the moment, the law says you can make that request after 26 weeks of working for any reason. It's not family related, it's for any reason. But at the moment, the onus is on the employee to set out the grounds for how this will work from a business's perspective, and for the employer to then assess whether that will work, but the employer can turn it down on up to 8 statutory grounds, the main one being that it doesn't allow the clients to allow you to meet client demand. So the major change is that employees are no longer required to explain that impact. So the onus shifts onto the employer to document that they have considered the request, including potentially trial periods, which does shift the onus somewhat. And I think this is, I say it's not a major change, but it's important because all of the time there are developments around office attendance, whether it's complete flexibility, whether it's 2 days, 3 days, 4 days a week. We happen to work in the City of London. I feel that there's a trend towards a 4-day-a-week working basis. Most people are still within the 3. Most people, to be honest, are still sort of Tuesday, Wednesday, Thursday. But if you are advising a board, or you're on the board, or you're making the decisions yourself, you have to be cognizant that within the next 6 months, this change in the law will come in. So whatever communications you're making now, you have to have this in mind, that somebody might try and change the goalposts on you, or they may, you need to think about who you're hiring or what roles you're hiring. But the important message is you have to be consistent with how you treat people, because that's, as we know, where you might end up with potential claims. I'm just skipping ahead there, Aaron, on the slide, so I've covered that one. So we're now let's look at the general election and what the parties are saying. So the Labour Party proposals were updated earlier this week by Angela Rayner. Now, they've been signposting for a while the sorts of things that they will tackle. And there were some updates this week. They didn't cover everything that they had mentioned before, but we sort of packaged together what they've been signposting for a while. Now, of course, they've said a cast iron commitment that an employment rights bill will be coming in the first 100 days. What's it going to contain? The major change that they have signposted is this day one right not to be unfairly dismissed. So, as you will no doubt know, you have the right not to be unfairly dismissed after 2 years of service, or actually 1 year and 51 weeks of service. It's been that way since 2012. It was 1 year of service from 1999 to 2012. And that was actually quite tricky to deal with, because you have a great deal of comfort knowing that you don't necessarily need to follow a fair reason and a fair process, or even have an appeal potentially within that first 2 years. It was a bit more tricky when it was only 1 year. It's going to be very hard when it's day one. And that's going to change. If it comes in, that's going to change. We've got a slide on this coming up, how you will deal with that from a practical perspective. The other major change, which wasn't mentioned earlier this week, but has been mentioned before, is to not have a cap on unfair dismissal awards. So we're currently at around 105,000 plus a basic award of around 20,000, or the lower of a year's pay if lower than that. It's a high number, but there's a huge amount of potency for individuals to be able to claim an uncapped award, because the starting point for settlement is a lot higher. And if you can't put a cap on it, and it still comes down to damages, you can construct a claim with career-long losses in the right circumstances. So those two changes will be fairly fundamental to the way in which we practice if they were to come in. Other changes that they've signposted are around the gig economy, are around 0 hours contracts that the Labour Party has never liked, because they feel that it is an attempt to try and manipulate the numbers of people who are in employment. And so they would ban 0 hours contracts. They would have a single definition of worker, because, as you're no doubt aware, we have two types of workers, for want of a better word. We have employees who have full employment rights, who have a mutuality of obligation, who are required, the employer is required to provide them with work, they're required to do it. And we have workers who provide work personally, who have certain employment rights, but not everything. So they don't have the right to paid holiday, for example. And this actually goes to the core of the business model of an Uber, for example, because at the moment, you may have seen the European Union is contemplating legislating to make this exact change, to say that anybody who provides work personally has the status of employee in each member state outside of the UK, and therefore will have holiday pay rights and other such rights. Uber is trying to challenge that coming in, because it won't come in automatically in the UK. We're likely to follow it, I would suggest, if the Labour Party comes in. But Uber is challenging that, saying, well, if it does come in, it changes our business model. We'll have to close down in hundreds of cities in the European Union. So that is an interesting development if you employ people on those types of arrangements. Other initiatives that I've just put at the bottom, aside from the union initiatives that they're talking about, and rowing back from years of Conservatives sort of whittling away at the rights of the unions, is this right to disconnect. And that's another European Union right which is in force in several member states, which will be very hard to, I think, legislate for, but also to police in practice. So this is the idea that you finish work at your contractual hours and you've gone home and you no longer communicate via email and what have you. So that is another idea that they have suggested may come in. The Conservative Party is, I've already sort of talked about much of what they have signposted. The other recommendations around the Good Work Plan from December 2018. These are recommendations around expanding family-friendly rights, taking paternity leave at any stage in the 12 months, maybe extensions to parental leave, those sorts of rights. But if you look at the two side by side, you can see that trend and that theme that I'm was alluding to at the beginning. It's to do with changing the bargaining power slightly in favor of a work-life balance, in favor of two working parents, in favor of the ability to have protection at work, to be able to bring a claim if you're wronged, and therefore it does shift the onus onto the employer, regardless of your culture, just to be cognizant of how employees are going to approach this transactional relationship with the employer going forward, as Bridget was alluding to. The other main change that Bridget will talk about shortly is to non-compete reforms. But I just want to sort of wrap up on this section to talk about what sort of takeaways you can have from this shift in emphasis. So, as I say, I think there's going to be a greater emphasis on employers' duties, coupled with the expectations of people coming into the workforce. So the types of questions that you'll get, the types of concerns, allegations, grievances, etc., will be, I feel, along this sort of theme. What are you doing as the employer to make sure that I feel that this is the right place for me, it's the right place for my career, that I'm not anxious, that I can bring my whole self to work? These are the sorts of issues I feel that we're going to get more of. And while there's no new law to offer employees that protection that they feel that they're entitled to, the perception of a poor working culture can have negative connotations on hiring, on retention, on PR, potentially on the longevity of somebody in a leadership role. And we can see those things happening very, very quickly and played out in the public domain. So the direction of travel is rights around flexible working, family-friendly rights, work-life balance. And I think you should have in the back of your mind this: if unfair dismissal becomes a day one right, what does that mean in practice that you're going to have to do? I think some people would say we're just not going to hire people, or we're going to be incredibly careful about who we hire and the types of background checks we might do. We might look at lengthening probation periods. We might look at having two-stage probationary period where you're past the first gate, but you've got another gate to go. We might shorten notice periods. I think also if we know that this change is going to come in, we might try to manage HR matters in a more hands-on way before the change comes in, if you have somebody with less than 2 years service. But going forward, you will be documenting performance management, appraisals, conversations, informal conversations, a lot more. So that will change the way that we need to approach it. I'm going to pause for questions at the end of this section. So Dan, if there are any that have come in, fire away, be kind.
Thanks very much, Christopher. I think that you and Bridget have done a fantastic job so far covering everything. We haven't had any questions in so far, but to our audience, you will get these opportunities at the end of each section to send in your question. So please do, and we'll make sure to get those answered for you.
Wonderful. Okay. All right, I will step back. Thank you.
I'll plow on. Just to your last point, Chris, I just think it's interesting as well with the context of culture and how important that is. I think it's equally important to say if your culture is, and some people want this out of a job, I want to get paid well and I want to come in and I want to leave and that's all I want from my job, then that's okay too, obviously within the realms of health and safety legislation. But I think it's an expectation, if you brand yourself as a certain employer, you really need to stick by that. That's my opinion. Anyway, on to restrictive covenants. So as Chris said, I am going to talk about the changes to non-competes, both here in the UK and in the US. But back to basics, I'm sure most of you are aware of what a restrictive covenant is, or post-termination restriction, PTRs, they're also known. But just to make, for the sake of completeness, a restrictive covenant is something, a contractual term, that restricts the type of action an employee can take when they leave employment. So it covers a whole suite of different things. The most common, as I'm sure you're aware, are non-solicit. So you're not allowed to hire employees or customers or solicit customers when you leave and you go to a competitor. A non-deal, much more potent than a non-solicit. It means you can't even speak to your previous colleagues or clients, for example. And then there's the non-compete. So when we refer to non-competes, we're referring to, and that's more US terminology, we're referring to specific clauses that stop people working for a competitor or stop them setting up a new business in competition with their old business for for a specific time, 6 to 12 months, and normally within a certain geographical area, although that's slightly changing with the move towards global businesses. So that's what they are in short. The legal position, there is no case law, there's no statute on or definition of what a restrictive covenant is, but the basic starting point is that all restraints of trade, those are restrictive covenants, are unenforceable, full stop. They are only enforceable unless you're able to prove as the outgoing employer that they go no further than is reasonably necessary to protect the specific proprietary interest. So as I said, there's no legal definition in legislation for proprietary interest, but in case law, they're recognized as intellectual property, confidential information, trade secrets, your secret source, as it were, your client relationships, your customer lists or data, and your stability of the workforce. So the idea that you want to prevent a whole team of people moving to a competitor. And the difficulty that we always see regularly with clients in drafting these sorts of things is that because they are about reasonableness and potentially objective and subjective tests, how do you know what reasonableness is? And the idea is that the restricted covenants, when you're drafting them, you must think about, are they tailored to the business? Is this person customer facing? Should they have a non-solicitation? Or are they supplier facing? Maybe a non-interference provision is better for them. So it's a lot of work is to be done at the front end. And if you have boilerplate clauses for everyone in your business, they're just not going to work when you want to enforce them. So it's a front end thinking job. And in order to enforce a covenant, an employer must show that the confidential information, for example, or the trade secrets that an employee is taking and using at their competitor will harm their business if that happens. So there's quite a lot to do in order to enforce a non-compete. Next slide, please. So that's the general gist of it. Going forward, we're going to speak about the changes in the UK and the US, but we're going to only focus on non-competes because the changes in both the UK and the US only apply to non-competes. They don't apply to non-solicits and non-deals and non-interference. So why non-competes? What's the issue with them? Well, generally from a legal perspective, the courts prefer if you use a less restrictive manner to protect your business. So where a non-solicit should work, is that enough to protect your client base? Or a non-deal, if they are enough, then you don't need to restrict someone from moving jobs and working and earning a living. They certainly don't like it where it looks like a punishment. So just because I don't want my employees moving to a competitor, just because that doesn't look good for our branding and our reputation, that's simply not enough. But more than that, and this is where the government from the UK and the US are looking at it, is they looked at California, Silicon Valley. In California, restricted covenants are unlawful. And there they can see the entrepreneurial culture growing, they can see competition, and coming out of COVID and the cost of living crisis, etc., both governments are trying to increase job market moves and keep people in work. So you can kind of see the reason for the change potentially. So what are those changes? So in the UK, it's pretty straightforward. In lieu of an outright ban, the UK's proposal is to have just a maximum 3-month restriction on non-competes, and that will apply only to employment contracts. At the moment, we don't know when it's going to come in. It currently says when parliamentary time allows. I'm not sure it's quite at the top of their current government's agenda, so we'll see when that actually comes into fruition. But if it does, it's also not clear what the limitation will apply to. So will it apply to workers? Will it apply to consultants? Will it be retroactive? Will we have to write to our employees to say, actually, the non-compete that you currently have is no longer valid, and actually we need to get you to sign a new one? Does that require new consideration? Or will it be straightforward, and will they say all non-competes that are more than 3 months will be deemed to be 3 months only in length? So at this point in time, still a lot of questions. And as I said, non-solicitation covenants are outside the scope of the changes. And then looking to the US, as we always do in this type of scenario, the US is going to follow California, so non-compete clauses in employment contracts will be completely banned. And they've also gone a bit further than us at this stage and said that employers must provide notice to employees rescinding their current non-competes, and that there will be potential fines or penalties if employers are seen to be trying to prevent people from working and going to a competitor. Will it survive the challenges? Who knows? Lots of different states may challenge it. It's still at the moment within business sectors and potentially in financial services very controversial, so who knows? But I'd be interested to know what you think, Chris, looking at the US, what your thoughts are generally.
Yeah, thank you. As Bridget says, a lot of these sorts of issues mirror or try to mirror developments in the US or what clients in the US would like. So whether or not this change passes all of the necessary court challenges in the States, what you tend to see with US drafted non-competes is a payments provision that says we will pay you for the duration of the non-compete, basic salary only. So if that isn't the major component of your compensation, then it doesn't act as a full incentive. Not always 100% pay, sometimes it's 50% pay. We also see, because employees in the States will only have, the default position is they're employed at will unless they have an employment contract. So if you don't have an employment contract, you may have a separate agreement to contain, for example, any incentive terms or any protection of IP. You tend to find non-compete provisions crop up in those documents, which arguably are not an employment contract and therefore may be allowable. Important thing to note there under English law is if you are asking somebody to sign a restrictive covenant, a non-compete, there must be consideration. So if it's in their employment contract, the perceived wisdom is, the consideration is, we're going to pay you some money to do your job under these terms. If, for example, somebody is asked during their employment to sign another piece of paper, and they're not paid any money for that, and that piece of paper says you now can no longer compete when you leave for a particular period of time, that's unenforceable unless there's some payment for that. So that will be something to look out for and sometimes trips people up.
Thank you, interesting. So how do we deal with these potential changes? Well, in the UK, we certainly have garden leave periods, which are largely unaffected. They're de facto non-compete periods. As Chris said, it's relatively common in the States to pay people out for their non-compete restriction period, but we use garden leave provisions, so that's still going to be there. Might consider lengthening them if you feel you need to. Think creatively about notice periods. I think the common market position in the UK tends to be reciprocal notice periods. Employee has 3 months, for example, employer has 3 months. But maybe with these new changes, you might want to think about how you can use notice periods to your advantage. It might be that when an employee resigns and they're more likely to be leaving in competition, that they have to give 6 months notice. But if the employer gives notice for something other than cause, gross misconduct, it might be enough that you give them just statutory notice, thereby decreasing the cost of potential exit. So, whatever works for your business, but there are tools that you can still use. Most importantly, and I think Chris built upon this earlier as you were speaking, is the idea that, well, they're not banned at the moment, in any kind of corporate transactions and shareholder agreements, consultancy agreements, and in any incentive plan, so bonus, share, option, equity-based documents, which in my experience, and I think this is true of the market, is that we're seeing way more of these with the kind of entrepreneurial culture of startups. People tend to get lower salaries, but potential higher incentives with shares or equity or bonus structures. So you can use those documents to include your non-competes and potentially prevent people competing that way. Which will be interesting to see if people do that, and that's something you can start to do now if you aren't already in preparation. Settlement agreements, at the moment they're not included in the proposed limitation period, so who knows what will happen. But as Chris rightly pointed out, you need consideration, you need money for new covenants. So if you're looking to agree new restrictions in your settlement agreements, it might make the cost of settling a little bit more expensive. So just one to keep in mind. I think that's where we leave non-competes, unless anyone has any questions at this stage.
Or on the topic
or anything.
Thanks very much, Bridget. We actually have had a question come in to the first section of the webinar. Will the changes Chris spoke about apply to companies of all sizes, or any exceptions for small companies, so 50 employees or less? And I don't know if you just want to reiterate some of those changes, Chris, before answering that, if you're able to.
I am not aware of that level of detail, that it's going to impact some companies and not others. At the moment, it's going to impact everybody. That's the sort of detail that gets hammered out when they come to present the bill to Parliament and somebody lobbies for a small employer exemption. So, for example, off the top of my head, there's one under 2P that if you're fewer than 10 employees, you don't have to elect employee representatives when you inform a consultant. But Other than that, for all of these new changes that we talked about, the right to request flexible working, changes to the gig economy, it's a one size fits all, I'm afraid.
Brilliant. Thank you very much, Chris. So that's all of the questions we have so far, but please do continue sending them in and we'll pose them to Bridget and Chris.
All right. Thank you. So we're going to segue now into changes that are happening in the workplace as an intro to the final topic that we're going to cover, which is at the end of that slides, which is data subject access requests. So I mentioned at the beginning that I feel that employment issues tend to be cyclical. So I'm thinking primarily of the financial crash in 2008 and what we saw there and around that time. So for those who were in practice 15 years ago, there obviously were a lot of redundancies, reductions in force immediately in the months following the collapse of Lehman Brothers. And at that stage, in general terms, I felt that the dismissals, terminations were dealt with in the same fashion as any other. They happened quickly, they happened for an understood, known reason. There was not much pushback for people who lost their jobs because they understood it, and they received settlement which was commensurate with what their expectations would be for that employer, for that type of job, for that level of compensation, and in return signed settlement agreements, and away everybody went. And at that stage, while there was a lot of concern and panic, people hadn't been through it for a while, and as ever, the feeling that you would get another job on the other side. When things didn't pick up in the new year, early January, February 2009, and then there was another wave of redundancies, at that stage, it became a lot harder because employers didn't necessarily want to part with the same level of settlement because they had their own economic uncertainties, and employees no longer felt that they were able to bounce into another job so quickly. And as a result, you had that perfect storm where the only way out for employees was to bring a claim for unfair dismissal or shoehorning it into some other header where there would be uncapped awards. So I feel I'd love to hear from others, and either through the questions or get in touch with us separately, but I feel that there's some parallels between that situation and what we're feeling now through the cost of living crisis, is that people do have financial concerns, worries about their livelihood. Will that drive more claims? Well, we don't know, other than what we see anecdotally, because the tribunal data is always 1 or 2 years behind. So we don't have any hard evidence for what's happening now, but we are seeing more claims, not necessarily claims going to full hearing, because the tribunal system is so bunged, it can take years to get a full hearing, but certainly more claims being alleged or being people chancing their arm and being brought. So I feel that there's some parallel there. And also this idea that, that Bridget talked about earlier, that there is a sense of injustice, that if you feel that the bargain that you did with your employer hasn't been met in practice, that you feel shortchanged, that you feel cheated, that you feel that nobody's listened to you, you had a grievance, you had a disagreement, you were stressed and anxious, you must have a remedy. And it's always been that case. I must have a remedy, and they speak to a lawyer, and the lawyer has to deliver the disappointing news that there is no remedy, but if there's a protected characteristic angle to it, then we can argue discrimination and maybe go for a higher level of settlement. And the downside with that, and I think this is something in the mischief of the Labour Party's idea to strip away the qualifying period for unfair dismissal claims. The downside for that is for all of those genuine discrimination claims, there are any number of claims that have been brought in order to achieve leverage and a higher settlement. And that, of course, greatly devalues, in non-monetary terms, genuine instances of discrimination. But, and I mentioned this earlier, I feel that without necessarily knowing it, employees who say, you have a poor working culture and I have suffered stress and anxiety as a result of it, are outlining a whistleblowing claim if they have made that known to their employers. So if they have a reasonable belief, and if it's in the public interest, and I think public interest for these purposes will be determined very narrowly. So if you talk about the fact that you have been treated poorly at work and you feel that as a result your mental health has suffered and you're not being able to earn a livelihood, I feel that that will be quite a low bar to demonstrate that that's a public interest disclosure. Then you have become a whistleblower, and a whistleblower is entitled to injury to feelings and is entitled to uncapped damages. So an unsafe culture, blowing the whistle on and endangering somebody's health and safety, including your own, could become a whistleblowing claim. But if the Labour Party removes the 2-year qualifying period for unfair dismissal, there will be no need to shoehorn it into a whistleblowing claim. Simply people will resign and claim constructive dismissal, and you're dealing with the same gamut of problems. We were talking earlier, Bridget's got an interesting take on other things that you're seeing.
Yeah, and I think we were talking about just the general rise in claims, but what sort of claims we're seeing. And in my experience, and I think this is backed up by the stats, although as Chris said, they're a few years behind, a couple of years behind, but particularly in the city of London, the age discrimination claims are going up and are certainly very high. And the reason for that we can only kind of surmise is that people are working much longer. The retirement age obviously went up a few years ago, but we've got an aging population. So there's a general trend of older people leaving the workplace, and under different circumstances they obviously feel aggrieved for the way that they've been treated, for good or for bad. So I think that's something just in your own workplaces just to manage and to be mindful of, that is, you know, far exceeding the discrimination claims that we're seeing at the moment.
Thank you.
Other forms of discrimination, I should say.
Okay, so in the last 10 minutes, we're going to dive into the final topic, which is data subject access requests.
Yes, so I'm going to talk about data subject access requests, or DSARs as we call them, or SARs you might hear them also referred to. And I think every employer could be forgiven for groaning when one of these turns up on your desk, because they can be a nightmare. In terms of what is happening, we seem to be seeing a bigger increase in these, and as it says on the slide, DSARs have been around since 1984, so they're not a new thing. Why are we seeing so many of them? Well, I think it's probably because the employees can use it to access their personal data, i.e. they can access information about their performance reviews, about why they were terminated, their redundancy selection criteria. This is either potentially before they've been terminated, or they're looking for that smoking gun email that says, we fired this woman because it was a hassle because she got pregnant, type of smoking gun type document. So I think that's why we're seeing an increase in them, but obviously interested to know if you think differently. Is this lawful? Can they do this? Yes, is the short answer. DSARs, basically, you can only refuse them on a very high bar, either if they're manifestly unfounded, which is essentially a sort of a bribery type scenario, or they're excessive. And excessive doesn't mean that just because we have to search 2 million documents to find your data, that's excessive and we can refuse to comply. That's not what the ICO says. So basically, your obligations as an employer or as a data controller of your employees' data is to respond to the DSAR. It's their statutory right to put one in. And your response, however, can be reasonable and proportionate in your search to find their personal data. So what does that actually mean? It used to mean searching your Outlook, searching a filing cabinet, and your servers for some documents relating to your employee. That's now changed. And as you can see, the forms of communication that we're using and are ubiquitous throughout people's workplaces and general social lives are listed on there. So Slack's, Teams, WhatsApp's a massive one, Bloomberg, personal devices as well. So the blur of hybrid working between work and home, people using WhatsApp maybe to communicate with each other, they download a document onto their personal laptop, they email themselves something, probably in breach of your IT policy, but they do that because they're working from home and they've forgotten something on their desk. You can see it a lot more. In terms of what you actually have to do, this is quite a tricky one, and this is where most of our clients find this quite difficult. So aside from the business confidentiality challenges that this poses, data protection perspective, employees may be processing data about their colleagues, about clients, on their devices, on their own devices, or through their instant messaging apps, which ultimately the employer has no access to, but they're deemed to be the controller of under the legislation, i.e. it comes within the data subject access request remit. So in terms of how the employer deals with this, they have to figure out how they need to search these, or how and if they need to search these mediums, whether it's WhatsApp's on a work device or someone's personal text messages. DSARs, I should say, are commonly, as we've noted before, submitted as part of an employment dispute. So you need to ensure that when you're dealing with them, you treat them properly, because employees can add it as a victimization claim if you fail to do it properly, or as a further detriment, unfavorable treatment if they've got a whistleblowing allegation. So just to be mindful of that. And of course, if you fail to search the requisite documents, or your search is too narrow, the individual is going to complain that you're in breach of the GDPR. So it is quite difficult, but thankfully, the ICO have given some guidance recently. Well, thankfully or not thankfully, it's pretty vague. You're supposed to assess to what extent personal devices or instant messaging apps are used for work purposes. So as I said, if they're just used for social communications, colleagues are texting each other private message about going for drinks after work, that's fine, that's absolutely fine, and that probably falls outside the scope of the search. But if you're using messages or Slack for communications, or WhatsApps for organizing logistics of a work trip, for example, and it's acknowledged by the employer that this is the medium in which to do so, they're going to potentially fall within the scope of that. And the reason why that is in the second bullet point, you can see of the quote from the ICO, the regulator's guidance, where they say, we don't expect you to instruct staff to search private emails or personal devices or instant messaging apps unless you have a good reason to believe, it's that good reason to believe that you're holding relevant personal data. So what does that actually mean? I think that means, do we condone it as a starting point, the factors that you consider? Do we allow, do we know, do we actively encourage people to use Slack, Teams, WhatsApp, their personal phones? And if so, then as I said, it'll fall within the remit of the DSAR. And potentially that means that you need to get people to hand in their phones so they can be searched, worst case scenario, or what we've done quite regularly in the past is ask employees to search their own phones for certain personal data relating to an individual. But of course, this causes so many problems with people's privacy, and not to mention the logistical faff of it. So it's one to bear in mind, but at the very least, the ICO have come in with some guidance which we didn't have before, which I think is relatively helpful. But in general, people are, as I noted before, people are nervous about this. It costs a lot, it takes a lot of time. There's some employment potential issues with victimization and detriment. But why are we so nervous about them? And I think that's because of the threat of the GDPR and breach of the GDPR. But in your experience, Chris, I'm not sure what you think about it. Like, how often does the ICO actually get involved in these types of situations if you don't deal with them properly, or you don't deal with them?
Yeah, because we see loads of different types of responses from clients that are either we're just not going to respond to this, or we'll back ourselves to settle this matter so that we don't have to respond to it, or we will just hand over absolutely everything, or we'll be a bit more cagey about what we hand over. And I think all of those responses are correct, even though legally they're not. Bear with me. That unless you get a complaint from the individual to the ICO, and the ICO then asks you to explain yourself, then you've managed your legal obligations. But in our experience, the ICO is quite short-staffed to deal with these sorts of things. If you get a complaint via an employee, the ICO will likely either write to the employee to say, sorry, we don't have the time to look into this, or they'll write to you as the employer and say, can you explain how you've dealt with this because we've had a complaint. And once you have delivered your explanation, that might be the end of it. But you just don't know, because of the scary fines that are out there attached to it. You don't want to be the employer where they begin to audit your GDPR practices. So that's why, as I say, all of those approaches are correct, delivered with these risks in mind.
Yeah, I think that's what we've seen, is that a disgruntled employee's DSAR can somehow be the window to a commercial audit of all your data protection policies and procedures in your wider business. So I think that's more than potentially the employment side of it. It's that's quite scary. So how do we deal with it? Well, ideally we'd avoid the issue in the first place. So the simplest way is just to have a policy or guidance that says we don't condone the use of WhatsApps for business purposes. I know, for example, FCA regulated businesses, they can't speak to clients over WhatsApp, everything has to be recorded. So, clear policies on that, and bring your own device policies are really helpful. But I appreciate, particularly I'd say in the startup market of business, maybe your business doesn't have enough money to provide everyone with a work phone, so they use their own personal devices to contact each other and conduct business on their own private phones. So sometimes it's not as straightforward as just to say you can't do it, but obviously clear policies on what you can and can't do, and the parameters will help you justify when an employee asks you to search their colleagues' phones or their WhatsApps. You can go back and respond robustly with a no, with a range of reasons why you don't need to do that. So I think it's just being very clear up front what is and isn't allowed.
Thank you.
Yeah.
Any questions on that, Dan? We've just got one more slide in the last 2 minutes.
We've had a couple of questions in. I think that the one, just looking at the time, the one that best resonates with Bridget's presentation from Anne, and you may have touched on this, but it's always good to reiterate. Are there any suggestions on the best platforms to communicate with all colleagues, sort of including remote, non-desk based and field based?
I don't have a specific platform that I would recommend, but what I would say is we've had clients who've got the cheapest version of Slack, for example, which doesn't allow them to search for personal data. So you can't retrospectively go back and search for messages. The function just isn't there. And so that in and of itself is a breach of the GDPR. And then it means you're not able to, one, comply with your DSAR obligations, or to any disclosure obligations if there's any pending litigation. So what I would say is I don't recommend a particular platform, but if you are going to use one, Teams, Slack, for example, make sure you get the premium service.
Brilliant, thank you very much. I'll leave it to you for any closing comments we have before we finish the webinar.
Thank you. So final slide, last 30 seconds. Just to sum up, the direction of travel is around new legislation and new recommendations that pertain to mental health, workplace culture, and the employee's perception of what it means to come into work and what the employer's obligations are. And all of the issues that are associated with that will be the types of questions we expect that you will have to deal with. There are some things coming down the pipe, the day one flexible working request. I would invite you to think about your hybrid working communications. With that in mind, that's a 2024 right that will come in. Day one unfair dismissal rights will be hugely exciting, potentially uncapped awards to boot. I think that will have the biggest impact. If the Labour Party comes in, It will be something they put into the bill in the first 100 days. So we're probably 18 months away from actual legislation to address that. So we have time. Non-competes, very, very interesting developments were they to come in the fullness of time. And I think with DSARs, let's accept that they will happen. We will see them. We want to minimize the headaches to ourselves in having to deal with them, and all of the reasons that Bridget gave for that.
Yep.
So, unless we have any questions on the hour.
Thank you very much, Bridget. Thank you, Christopher. That was a fantastic, very informative webinar. I think it was incredibly important as well. To our audience, there will be a recording of the session sent to you. Please do share that with anyone you feel will benefit from that. And please do get in touch with Bridget and Christopher, any questions that we weren't able to get to, and any questions that you might have subsequently. So thank you once again to everybody at Katten, to Christopher and Bridget as well. And I hope you all have a lovely rest of your day.
Thank you, Dan.
Yeah, thank you. Thank you very much. Bye.